Hi, everyone, and welcome to our third Thursday webinar series. This webinar is called Ground Rent, What You Need to Know. And I want to thank the audience for tuning in and joining us for this presentation. So just a couple of quick housekeeping tips before we dive in. The audience will be muted during the presentation, but please do type any questions that you have into your question or chat box, and I will monitor those, and Louise will answer questions at the end of the presentation. But feel free to type in any questions you have throughout. Um, there is a PowerPoint for this presentation, and it should be available via the handouts section of your GoToWebinar control panel, but if anyone's having trouble getting it, I can also send out the materials after the webinar, so feel free to reach out to me. This webinar will be recorded and it will be available via MVLS's website, so if there's anything that you miss or you feel like you want to come back to, you'll also have access to the recording and the materials in that way after the presentation. So I'm very excited to have Louise Carwell with us today to give this presentation. Ground rent is an issue that comes up in a lot of our housing cases. There have been some relatively new changes to the law regarding ground rent, and Louise is going to get into those. It's certainly an issue for many of our clients. It's something that a lot of people know exists, but it's very, very poorly understood. So I think it'll probably be relevant to a lot of your clients as well as you are working with MVLS clients or with your private clients. So with that, I do want to introduce our speaker today, who is Louise Carwell, and thank her for being here with us. She is a senior attorney at Maryland Legal Aid. Her practice focuses on bankruptcy, consumer law issues, foreclosure, and tax sale, and she conducts numerous trainings. She's conducted numerous trainings for us, but also other venues such as the Maryland Judicial Institute, and she also teaches consumer and bankruptcy related courses and has taught at UB and University of Maryland. So I want to thank Louise so much for being here with us to give this presentation. She's certainly an expert in this area, and to thank you all for attending. And with that, Louise, I will go ahead and turn it over to you.
Okay, thank you so much. I am going to go through my ground rent slides. Certainly send questions if you have them. I know that many of you may be doing a lot of webinars during this time. I certainly am, and they've all been, of course, focused on COVID-19. So maybe this is a nice little break about an issue that is separate and apart from that. Our office has dealt with ground rent issues for as long as I've been with Maryland Legal Aid, which is a really long time. There used to be many more filed until about 2007, and I'll talk about that. And just the history of ground rent. If you're a person who enjoys history and legal history, then I hope you'll enjoy the background of this. So the ground rent system came over to this country, to the colonies during the 17th century. For the most part, ground rents are not something that many states have adopted. Maryland and Pennsylvania certainly has many. And the idea was that it might be easier for individuals and families to own a home if they didn't have to pay for the ground. And so especially in Baltimore, these were established, as you know, there are all these row homes in Baltimore that were built for folks who worked in a lot of the industries, and they were not very well compensated, but if there were homes that were going to be sold to them, maybe a little bit less expensive if they didn't own the real property. And so there are also commercial ground leases. We're not going to talk about those during this webinar. A ground rent is a lease, and it is filed with the circuit court. It's a lease that's usually for 99 years, and it renews forever. The real property article is where you will find statutes relating and provisions relating to ground rent. And it is really a form of investment. So what you're looking for, or you may run into if you look on the Maryland Land Rec, you might come across, when you're looking up a deed, this deed that has not just your particular property that you're looking at, but many, many properties. And that's because that's how these deeds are prepared. They will list the lease that is attached to every property that that particular holder of the ground rent has, and then it is filed in the ground rents. And often folks hold, and I say folks, investment companies that are normally single individuals or families, and they may have hundreds of these ground rents, and they are small amounts of money, anywhere between $45 every 6 months to $120 every 6 months in these 2 yearly installments. And they just, in theory, have these funds that come to them every 6 months, and they have all these multiple properties. And if they hold hundreds, then you can imagine they're getting some money on that. So the holder is the owner of the ground rent, or the landlord, and then what we would think of as the owner of the house is known as the tenant. So that tenant does not hold that land that is sitting underneath the structure. Just to give you a sense of where ground rents are in Maryland and how many there are, this is a very recent update. There are over 92,000 ground rents still out there, most in Baltimore. But then this sets out where they are, then Baltimore County. And so these are certainly cases that will arise. Because individuals just haven't recognized they have a ground rent or how to deal with it. But they're certainly active in the state of Maryland. And I've just set out these statutory provisions for you. These are the ones that you really want to focus on if you get a ground rent case. So just talking about these, what I used to see a lot of were cases that were filed as ground rent ejectments, and the process has changed so that before you get to the ejectment process, there are many steps that have to be followed prior to that. But all those requirements are, for the most part, in these particular provisions. And then there are a couple more that I have set out in the slides, but that's really where you want to focus your attention. I have a couple slides here on new changes to the law. I've set them out here. I sort of debated whether or not to set them out here or later on. So I'm going to set them out here for you and touch on them. And I think as we go through the discussion, if you remember these or go back to them, they'll make some sense to you. There were several pieces of legislation introduced this year that are now waiting for the governor to sign them. So these have not yet been signed. If they are signed, I believe they would go into effect probably in October of this year. And I think the governor will sign them. Many of them were administration bills. If you've been watching the governor's press conferences, he did say, I think about a week ago, he was not going to sign any bills that had a fiscal note attached to them, which means it was going to cost the state money. None of these bills had a fiscal note attached to them. So I think that you'll see these all going into effect. And for the most part, a lot of these were clarifying legislation. So this first one, which will amend Section 8707, is just to make sure that if someone buys a property, then they're not on the hook from unpaid.
Hey Louise, maybe it was just me, but I think I lost your sound. Are others in the audience having trouble with sound? Yeah, other people lost the sound too. Louise. Oh, Louise, it's saying you're offline. I think you might be, let me, sorry for the technical difficulties, everybody. I may go ahead and call Louise because if she's offline, she may not be hearing us right now. So hold tight for just a moment and hopefully we will be right back. Sorry for the technical difficulties.
So what occurred was that in 2000,
we lost your audio for maybe the last 2 minutes. Sorry, I was just trying to call your cell phone to let you know.
Oh, okay.
You may have to go back a little bit. It said you were
Sure.
offline. I think the internet connectivity might have been messed up.
Okay, so let me go back just a few slides. This was the second of the new changes. It would, if you didn't hear this, you have the right to pay off.
I think we didn't hear it. It's been maybe 90 seconds or 2 minutes.
Oh, okay. All right. So then let me move forward here. So prior to 2007, ground rents were a huge basis for litigation. They were filed en masse by ground rent holders. It was fairly easy to do that, and a person could be ejected from their house for not paying a small amount of ground rent. The problem contributed to a series of articles in the Baltimore Sun that were written by a wonderful reporter, June Arney, and another reporter as well. And they really follow this issue. And so what occurred was that in the 2007 Maryland General Assembly, a bill was passed that said you could extinguish unregistered ground rents. So ground rents were supposed to be registered with the State Department of Assessments and Taxation, but there was not really any remedy if you didn't. And so the Maryland General Assembly took action to just void all of those ground rents. And there was a huge outcry from ground rent holders. And so the Court of Appeals in 2011 rolled back that legislation and said that that was unconstitutional. The other thing the legislation in 2007 had done was to make it not possible to, they had eliminate the ground rent holder's right to re-enter the property and eject a delinquent tenant. And so that also was done away with. And new legislation was passed to deal with those issues and to both support the right of ground rent holders and as investors, but then significantly add protections for ground rent tenants. So I set out a couple pieces of legislation that were signed that went into effect. The most recent were some rewrites in 2015. If you look in the annotated code, you will see references to that. I think one of the most important things that came out of all of this was that, first of all, you must, if you're the holder, the landlord of a ground rent, you must register it with the State Department of Assessments and Taxation. So they have on their website, anyone can look up a ground rent, who the owner is, their last known address, all that information is out there. That's the only way that a ground rent holder can move forward if someone has not paid their ground rent. But you've got to be registered. And so that is very important and a protection for tenants. Furthermore, the holder can certainly has a right to move forward to collect their ground rent and to bring an action to enforce that. But there are significant requirements placed on them. They have to, they're limited in how far back they can go. And if they're going to bring an action, they have to follow certain due process requirements. So if someone is behind, then at least 60 days before they're going to take any action in court, they have to mail a notice. And now the language that is required is set out in the code. If it's not sent, then they can't collect an installment that's due under the ground rent lease, whether or not they're thinking of filing action or not. If you are the tenant and you sell your house, for example, then you have to give notice. I would think that normally your title company is going to do this. They are going to notify the ground lease holder, but that does not always occur. So I think that if you have a client that sold their house, they need to make sure that they took care of this. And the information of the last known address would be very easily with SDAT. Also, what's important is if the holder of a ground rent changes, and this can occur fairly often, I find, and this is where a lot of problems arise. The holder of the ground rent has to send the tenant notice. So as this is an investment, they will sell their investment to somebody else or transfer it to another family member, for example. And the reason I say this is a major problem is if you have a tenant who is used to paying their ground rent as long as they've been in the property to a certain party, and they get notice, and the notice may actually be with the address of the new holder. So often they just don't pay attention, or they lose that letter and they don't know now where to send the ground rent payment. And so they either send it to the old owner who doesn't pass it on, or they get too confused and they don't send it at all. And this is just, this is so common. And then they start getting notices from the new ground rent holder. They don't know who this party is, and they fall behind. Another change that came out of the legislation in 2007 was that in the contract of sale, if there was a ground rent, there had to be notice that there was a ground rent that was coming along with the sale of this property. And so that also gave the new owner not just notice, but that where the payments had to be sent. And then the fact that they could, right then at purchase, if they wanted to, they could simply pay off the ground rent, redeem it, and not have to worry about it going forward. And it has information about how to redeem the ground rent. So this was important in allowing new purchasers to recognize that they are just simply a tenant in under ground rent law, and maybe they want to deal with this right up front, pay off this amount right now, and not have to ever deal with it. Another reason why this is really favorable is that if you have an out-of-state lender, which most folks do, and they are escrowing money for taxes and insurance as part of a mortgage payment, some simply do not understand what a ground rent is, and they don't escrow for it. And that creates a problem for the homeowner or tenant when these are not being paid, and then they, a couple years down the line, get notice that their ground rent hasn't been paid. So if you're the holder of a ground rent, you can file for possession. Not a lien of a money judgment, but for possession. And they can only do so if they meet certain conditions. And that is that they have this lawful right to claim possession, that they've registered with the state. The ground rent has to be at least 6 months behind. And they have to have sent notice to the tenant that they are behind. And they would attach a copy of that notice. Just as with unpaid taxes, the holder of the security interest can pay the amount that is due. If a lawsuit is filed in the circuit court for ejectment, they are a party that does need to be noticed and made a part of the complaint for ejectment. There are certain amounts that the holder can claim, and some of those are set out here. I think that a secured creditor would simply, and that's your lender usually, or servicer, they would just pay off the amount that's claimed. And then of course they're going to go back to the tenant to reimburse them. So here are the notices for possession. There's a first and second notice, and I set this out. This language is taken pretty much right out of the code, and just describes the timing, what has to be in the notice. And then there are these fees that are permitted. So the fees are permitted if you get it right. I will say that ground rent holders normally will be correct on the timing of their notices. The language of the statute is reasonable late fees, interest, collection costs, and expenses. And those expenses are normally for mailing and service of process. There are going to be attorney's fees that are often added. And so you need to look at these closely if your client has gotten to the point where a complaint has been filed. And then here's the second notice and what that has to incur. So at this point, when you get to the second notice, there is a limitation, as you see in part 3, reasonable late fees, interest, collection costs, and expenses. They're not to exceed $650. And those include those 4 items set out below. If any of you have ever done a tax sale case, you know that there are limits in the tax sale article about the amount that can be reimbursed for costs. And you'll also know that in every case, the purchaser in a tax sale will always ask for the limit. And so you will find that will be the case here as well. So I would say that you need to look carefully to make sure that these costs can be verified, and also to make sure that, for example, the ground rent holder is not asking for costs that they are not incurring. For example, if they did not hire a lawyer to file the action, they shouldn't be asking for attorney's fees. That's just an example of something you might see. And then here, just that the notice also has to be sent to secured parties. And so do these notices, not just the complaint, but the notice itself. And the secured party has to know that they can cure. So this is what happens if there's a failure to cure. Prior to the changes in the law, prior to 2007, failure to cure really resulted in the loss of many, many properties. Ground rent holders could take the properties for a small amount of money, and people were thrown out of their houses, these houses that they had lived in and invested so much in for this small amount of ground rent and some fees. It's a little bit more protective now, and I set that out here. They've filed their court action, they've attached their documents. They can file it, but they have to wait at least 30 days after they have sent that second notice. And then here's some further requirements. Personal service is required. So those of you who have ever dealt with issues of personal service, and I certainly see this, and I'll just go back for a minute to tax sale cases. There are all kinds of ways that plaintiffs try to get around this personal service in tax sale cases. And they may also attempt that in ground rent actions. They will not serve the person, but they will post it on the property. They will claim that they have tried to serve the individuals, and they will try to do alternative service, but really you have to hold fast to personal service. The individual should be served. and then the secured party has to be joined as a party. I will say in ejectment cases, I don't see ground rent holders being as fast and loose. My sense is ground rent holders just really want their money, and filing a case will give them perhaps more money in the sense that they get some costs and damages, but they are not so focused on ejecting the person any longer. They just want that stream of money. I don't say that for every single ground rent holder, but I think most of them look at this as a sort of passive investment, and that's for the most part what they're looking at. It is not as much to get hold of the real property as you would see in a foreclosure tax sale case. So you file your complaint for ejectment, and that weaves its way through the court system, the circuit court of the county where the property is located. And then if an order is entered, this is what can occur within 6 months after a writ of possession is granted. So you still have the opportunity as the tenant within that period to pay all the past due ground rent. And I think this was really, under the 2007 legislation, an attempt to really try to halt ground rent ejectments. It just gives additional rights to the tenant. And of course, ground rent holders can certainly negotiate with each other, but ground rent holders do not have the right to for self-help. So they do have to get a writ of possession. They can't just, once they get their judgment, come onto the property and try to dispossess the tenant of the real property. What has always been under the code, and what a lot of tenants either don't realize or don't pay attention to, is they can at any point redeem the ground rent. They have the right to do that at any point. And so what they need to do is they have to give notice of it, pay a fee. And this is the ground rent formula. And it's a formula that's been in effect in the statute for decades. And you simply follow it. It's fairly easy to follow. I think that most ground rents that you see are going to fall into number 2, so 16.66 of the annual ground rent. It doesn't come to a lot of money usually. And parties can also agree to another amount that is a lesser sum, if that's specified in the ground lease or if they negotiate amongst each other. So I always encourage my clients, when they come to me with this case, to really consider spending a couple $100 or $1,000 and just let's pay this off so that this will never happen again. Sometimes that's not possible financially, or sometimes folks just say, hey, it's just a couple dollars every couple of months. And I'll say, well, yeah, that's certainly true. But the problem is it's now costing you several $100s. And so as a result, wouldn't it be better if you just got rid of it? So I encourage you to have that discussion with your client. This is what a tenant has to do if they want to redeem. They give notice to the ground rent holder, and it's not immediate. That notice and their application, they have to post it or get SDAD to post it, and it has to be posted for 90 days on its website. And then they've got to pay it. Any past due ground rent has to be paid. And that redemption is conclusive. And as the new bill that was that I think will be signed this year, one of the pieces of legislation, it just merges with the title. So it's clear there's no more ground rent out of there. And even if that is not properly taken care of through a title attorney, the law presumes that it has merged with the title and that now you no longer have a tenant, you have an owner of real property, the ground and the structure. So I just touch again on these limits. What the ground rent holder can't do, the only remedy is possession. So it cannot become a lien, a money judgment lien on real property. There's no self-help possession, and then the costs and fees are limited under these sections. And those are the only costs and fees that are permitted. There is not often, but sometimes a dispute as to the amount of money or payment that's due. And so that is taken care of as well in the statute. And this is the process that the parties have to file. And while I don't address it here, if you look in the code, there are also situations where property has been abandoned or is held by the mayor and city council. Those are also in the code for you to take a look at. I don't address them here because those aren't the types of issues that you will probably see, but they could arise as well. So here the dispute, and again, 3 years is the limit that a holder can ask for. You would file an interpleader action and then reimburse the ground rent holder if that was the case. It's very clear the department is not liable for any money it receives. In addition to what may have become in dispute. And then there are some other SDAT responsibilities set out here. I think the SDAT site does a good job, not just with keeping the ground rents that are registered with it, but also lots of information, pretty step-by-step about how you file them, if you want to redeem, what to do, and they try to be as helpful to all parties as they can be. So there was a time when ground rents were written that they could not be redeemed. So that's no longer the case. If your lease has a section in it that talks about the ground rent not being redeemed, then this slide takes care of that. And so even though it was recorded at a time that you couldn't redeem it, now you may. Just make sure that you follow some of these time limits. The long and short of it is that basically at some point that provision expires. And so it's usually after 10 years from when the ground rent notice had that provision in it. So you as a tenant are going to be able to redeem at some point. the most common issues. Some I've touched on those already. Certainly you're going to have folks who they don't pay. They know they're not paying. They're, for whatever reason, just not making that ground rent payment. It's just one more bill they can't pay. I don't think they really appreciate that this can result in costs and fees moving forward. So it's a time to sort of educate folks to make sure it doesn't happen again, but certainly that can occur. They don't know who to pay. The ground rent holder changed and maybe didn't give proper notice, but maybe they did. And that sort of flows into they're confused about who to pay. A notice to pay is not sent. You always want to make sure that you see a copy of the notice and make sure that it is sent with the language that's required and with the process that meets what the code requires. If an ejectment case is filed, make sure that that procedure is filed with. Certainly if the ground rent is not registered, that is an easy way to take care of that case. I'll say that ground rents, for the most part, in these last couple of years, you shouldn't see one that's not registered, but always check on the SDAT website. And then there are always further legislative efforts. So this year there were actually 4 bills introduced. I was surprised by the number of bills introduced and that they did get passed. And just what that says to me is that ground rents continue to be a problem for people in those jurisdictions where there are ground rents, especially problems for the tenants. And the statute itself continues, the legislature always does try to continue to clarify it. I included the SDAT website right here. And I'm done. That is ground rent in a nutshell.
Well, thank you so much, Louise, for all of that information. That was extremely helpful. And what I want to do is I'm just going to go through a couple pieces of information about volunteering with MVLS. But while I'm doing that, if folks want to think about what questions they have, and again, type in your questions to the question box. We do still have a couple minutes left, so please let us know what questions you have, and I will let Louise know. So, okay, let me just go ahead and I'm gonna go through a couple of pieces of information about volunteering with MVLS. So, if you hopefully have taken this webinar and are interested in helping us out with some ground rent cases, it is not too difficult. As Louise mentioned, it's all very based in the statute and the requirements. So you can always look for those or other available cases on our pro bono portal, which you get to by going to our website, mvlslaw.org, and clicking on pro bono portal. This is what it looks like. So you can sort by type of case and or county to check out cases you might be interested in, and then you simply just click on learn more, and a paralegal who is responsible for that case can provide you with additional information on the case. I just wanted to highlight a couple of our upcoming virtual training opportunities that we have. Like Louise said, if you're interested in some trainings that are not necessarily about COVID-19, we have them. So we have a training coming up on May 5th called Deed Disentanglement, the Basics of Property Transfers and Estate Administration. So that might also be of interest to people who are interested in ground rent. Certainly comes up in deed transfer cases, and that is estate administration and deed changes are two types of cases that MVLS does place if you are interested in taking those and learning more about it. We also have on May 12th a webinar about self-employment tax pitfalls, and then we will be having a webinar on May 21st, our third Thursday in the month of May, about the intersection of consumer law and human trafficking. That might be interesting to those of you who are consumer law practitioners on this webinar. So just go to our website to sign up for any of these trainings and get the webinar link, and we hope you can join us. Also, just wanted to highlight that we have recordings of all of our past trainings available on our website. So any other area you might be wanting to brush up on while you are stuck in your home, we have available on our website. So please feel free to check out our recorded trainings as well. If you're not currently a volunteer, we hope you will sign up to be a volunteer today. You also do that at mvlslaw.org. You just fill out a really quick volunteer application with some information about yourself, and then we will reach out to you about how to volunteer with us. So that is the end of the presentation. And again, I just want to say a huge thank you to Louise for taking the time out of her day to be here with us. Louise, I have just a couple questions. One of them is if you had mentioned that if the holder of the ground rent changes, they have to send the tenant a notice. If you're dealing with a ground rent ground rent case, where is it a defense to the tenant not having paid the ground rent if they never received one of those notices when the holder changed possession?
So yes, certainly that can be a defense. It really becomes a question of a factual question that the new ground rent holder or the old one is going to have to provide proof that they sent it, and also you would want to look on the SDAT website and see when that information was updated. But yes, that would certainly be a defense.
Okay. Question that I have is, I mentioned that, you know, we do a fair number of deed change cases at MVLS. Have you seen a lot of situations, I think you kind of alluded to this, where the tenant can't find the ground rent holder because you know, maybe either that person has passed away or they've just kind of disappeared. They're no longer there's just, you know, it's become difficult to find them, and what can the person do in that situation if they just, you know, can't be found?
So that is a really good question. There were a couple of suggestions I would make. First, for them to reach out to SDAT and see if SDAT has any information or advice. The second would be that if this was an investment, it's an asset, or the individual who may have passed away who held all these leases, and at some point those leases may either become property of another family member or another investor. So I think the individual needs to try to hold that money aside as best they can, but really put it as, you know, suggest to them ways to sort of put things on notice that they've been trying, but their payments have been returned to them. I have had that happen, and it is very frustrating.
Yeah,
and I've advised those people. And the other thing is that the person wants to pay off their ground rent to redeem it, and they can't find who to redeem it. with. That's also very frustrating. And so after a period of time, you may need to think about, and this might be past what the volunteers may want to do, but to file a quiet title action.
Mm-hmm. Yeah, I think that, we don't handle a ton of quiet title actions, but in some of our more convoluted and complex deed change cases, sometimes that can come up. So certainly some of these can get pretty complicated. Um, all right, well, I don't currently see any other questions, so I just want to thank you again for being with us and for presenting. Thank you so much, and I think that concludes the webinar.
Thanks, and everyone stay safe out there.
Yeah, thank you. You too.
Bye-bye.
Bye.